Hello, good evening, everybody, and welcome to another Tuesdays with Mitch. I'm your paralegal and fellow host here at Proner and Proner, and today we have Mitchell Proner. We sit down every Tuesday to discuss burning topics. How are you, Mitchell?
I'm good. I'm good, Emily. How are you doing?
I'm good. I'm great. Happy Tuesday.
Thank
So
you.
every Tuesdays we sit down live with you guys to answer your questions and any concerns or anything you might have and hopefully get you to understand the personal injury world a little bit better. Today we have a great topic for you guys. Today we will be discussing, is it better to settle or take your case to trial? So Mitchell, what do you think? Is it better to settle your case or is it better to take it to trial?
Well, first of all, every case we're looking to settle because every client we have wants to get a good settlement early on for whatever they've injuries they've sustained. That's just the nature of people. They want a lot of money as quickly as possible, and we try to do what we can to get that for each and every one of our clients. But sometimes an early settlement is not possible. And there are a lot of different reasons why you might not be able to get an early settlement. First of all, it could be because liability is contested. Liability is who is at fault for an accident. Now, with a workers' comp claim, you don't need to prove fault. And with some types of labor law cases where there's a fall from scaffolding or a fall from a ladder, in many of those cases, you don't need to necessarily prove fault, just that there was a lack of safety equipment. But most cases, you're going to need to prove fault. And the other party, the ones that ultimately end up paying for the claims through their insurance carriers, typically can contest fault. And the more the money is at stake, the more they might want to see if there's any way they could get out of it by trying to show it's not their fault. Now, some cases, of course, somebody might be sitting at a stop sign and they get hit in the rear by a truck, and it turns out the driver of the truck is drunk and they test positive for alcohol and drugs at the scene of the accident. Well, clearly, liability is not going to be much of an issue, meaning proving who's at fault is not going to be that much of an issue. But in those cases, they might want to contest the extent of the injuries. Did you sustain injuries that were readily apparent immediately? Or did you go to the doctor a day or two afterwards complaining of pain? That maybe the origin is a prior injury or a prior condition that has nothing to do with the incident. Is it something that you were dealing with for a while and then it got worse because of the accident? You might be entitled to compensation for that, but the other side might contest the extent of your injuries that were from the accident. So sometimes it's who's at fault and the extent of the injuries that are at issue. Other times, the value of the claim is just so great that they're going to want to check out every possible aspect of the claim before they make a sizable offer. So let's suppose a case is a multi-million dollar case and it comes into the office. We know the damages are tremendous and we know our client is not at fault. Well, before the other side writes out a check for millions of dollars, they're going to have their attorneys look at it. And their attorneys are going to say, well, before we advise you to make that $1 million offer, let's take testimony. Was there a prior condition? Can we establish some culpable conduct? Meaning, can we establish that maybe the person making the claim is at fault also? So at times, there are reasons why cases go into litigation. Then, typically, after all discovery is complete and they found out who's at fault and what the injuries are, they might want to try and get it at a discount. And they might make an offer that's a little bit low. Now, any case if you tried that case before 50 juries with the same judge, the same witnesses, the same lawyers, but you tried that case in front of 50 different juries. So there were 300 people, and you divided them up into groups of 6, and you tried the same case in front of 50 different juries at the same time. And then afterwards, you had the juries deliberate on them, and they had them write their number on a card and put them face down on a table. Well, if you picked up some of those cards and you were the victim in that trial trying to get compensation, if you picked up some of those cards, you'd probably be really happy. And if you picked up some of those cards, you might be really upset. And then the rest of the cards would kind of go into some sort of grouping one way or another. But you don't get to try your case in front of 50 juries. You only try it in front of one. So that's the time when you have a serious conversation with your attorney and you say, what do you think the odds are that we're going to do better? Or in the alternative, what are the chances we come out with nothing? And those are the considerations you have to take along with your attorney and his advice or her advice and decide whether it's better to go to trial or whether it's better to settle.
So that was a great explanation. That kind of brings us to our next question. In conversations between a client and an attorney, who ultimately decides whether the case will settle or go to trial?
But the client has the right to ask the attorney for their advice. And they can also ask the attorney, what are you basing this advice on? And some of the things the attorney might take into consideration are, what's the maximum sustainable verdict on appeal? Because I've had the fortune of having a lot of verdicts that were large verdicts. And immediately afterwards, my client always says to me, oh my God, this is so great. Thank you so much. And I say, wait a minute, it's not over. This number is a big number. They're going to appeal this. And frequently they do. Frequently, they'll try to make an offer less than the total verdict. And we have the right to either say, no, we're going ahead, or, yeah, we'll give you a lower demand. So I had a case recently where jury came back with $4 million. We ended up settling it for 3.9. After the other side filed an appeal. And I told him, you're not getting a big discount on this. Forget about it. Of course, if my client said, I'll take anything, we would have taken less. But the client had the courage to stick to it. And so we got almost the entire verdict, and it was a large verdict for the injury sustained. Another case that I had, jury came back with, there was no offer on the case, and the jury came back with $800,000, and the other side offered $100,000. And we said, no, it's not enough. And then they came up with $250,000, and we said, no, it's not enough. It went up on appeal, and the appellate division let us keep $770,000. So we were right to let it go to appeal. But my client knew about every offer and could have gotten off the ride at any time. I give the client my advice. Another thing that an attorney can take into consideration, along with what's the maximum sustainable verdict for those injuries, because appellate decisions are something that an attorney can research. What's the most we could keep on appeal for these types of injuries? Another thing an attorney can do is they can run focus groups. That's where an attorney will actually present the case to a group of individuals outside the courts and see how jurors, and Emlyn, you've helped me find prospective jurors for these focus groups that we run. Emily's very good at that. When I need to get a room and I need to get jurors, and we set up at a hotel near where we're trying the case, we got to get people from the local area, and we try to get 20 to 40 people. And Emily's one of the paralegals in my office that's done that for me repeatedly. So thank you, Emily, for all your hard work in setting that up. And she knows the drill. But that's what we do. That way we're airing it out in real life before we go in front of a jury. So we kind of get an idea of what the issues are and the weaknesses, the strengths. And that's something else that we can present to the client in helping them to determine whether or not they might want to accept the settlement offer on the case.
All right, guys. Remember, we are live every Tuesday. Don't forget to call us. If you ever have any questions, you could always call 1-800-321-1234. Mitchell Proner is a personal injury attorney with over 30 years of experience, and we're always here and happy to answer your questions. And now, in comparison to settling and going to trial for a personal injury case, what are the differences in the timeline? Like, how long can settling a case as opposed to going to trial actually take?
Well, today we had a case that we settled, and the accident only happened 2 months ago. But the injuries were substantial, and we got all the money there was from the insurance, and there were no personal assets to seize. So we settled the case. It was only 2 months in. You can't get a trial in 2 months, not on this planet. Typically in New York, to go to trial could take 3 years. So during those 3 years, depositions are taken. There's an exchange of documents and proof during discovery. Then you get on a trial calendar. And then a trial could take a week. It could take 2 months, depending on the issues involved and how many doctors and experts are called. And I've had cases that I've tried as quickly as a couple days, and cases that have gone on for months. And it's not too different outside New York. I've tried cases in over 30 different jurisdictions, and sometimes cases go quickly, and sometimes they don't, depending on the issues involved, the amount of witnesses, the judge, the calendar, and it typically takes a case longer to go to trial. But the last case I tried, there was no offer prior to our going to trial. And then once the trial started, they started coming out with hundreds of thousands of dollars in offers, and we turned them down, and we went to verdict. And all of a sudden, we were looking for millions. So it's certainly worth it at times to go to trial, given the offer that's on the table and the potential upside of going to verdict. But anytime, it's up to the client to decide whether or not they want to go or whether or not they want to settle. I had a case in Connecticut where we wanted $750. This was also a case last year. We wanted $750. They only offered $250. I said to the client, "Do you want the $250,000 or do you want to take a verdict?" He said, "Let's go to verdict." Jury came back with a little over $2 million, and they paid it. Didn't go to appeal. They paid the verdict. So obviously, in that case, it was worthwhile. I can't think of a case. I'm sure there had to be one where we had an offer that was on the table and we took a verdict and came out with less. But I can't think of one. And I'm doing this over 35 years. And certainly I can't think of one in the last 20 years where I ended up worse taking a verdict. But I can't guarantee any case. No attorney that's ethical can say they know what a jury does. None of us do. But after doing it for a while, you kind of get an idea when a case is going in well.
That's a very honest response. I hear all the time, sometimes potential intakes or other clients who have other cases with other attorneys, they call and say, "Oh, this attorney has promised me this amount." And it's really just hard to say whenever their case isn't even nowhere near done. So that's a very honest answer, Mitchell.
Thank you.
Can you recall of what are your most recent settlements, and share if they were a surprise to you or if you were pretty sure
I
that
said
you knew where they were headed.
I settled a case today for 1.5 million. It was a case where a guy was loading a pickup truck, and it was a Con Ed truck, and he was working for an outside contractor. There was a project in the city, and Con Ed had some conduit tubes that they were putting in the below the pavement on the Upper West Side, and it was during the winter time, and he was taking these wrappers off these tubes, and underneath the wrappers that were plastic was ice. And we sued Con Ed because it was their truck, and we said they shouldn't have put these uh, trucks out on the road for them to be unloaded with ice on them. Somebody should have inspected them. And plastic on top of ice is a dangerous condition. They defended the case, stating that it was my guy that had the obligation to inspect the vehicle before unloading it, and they had nothing to do with the incident. And they made a motion for summary judgment, trying to get the case thrown out as a matter of law, saying my client only had a right to workers' compensation. We won that motion, and then there was an issue between Con Ed and their insurance company, because believe it or not, Con Ed had insurance provided to them by my client's employer. And my client's employer says, no, we're not paying for that. That's on you. And they went back and forth, and they couldn't decide the issue of the insurance. And before it was going to trial, literally tomorrow, settled today for 1.5 million. Now, that was today. Last week, I had a case that I settled for $1 million, where a guy was on the side of the road blowing leaves, and a woman pulled over, and she was driving on the shoulder to turn into a mall parking lot where there was a veterinarian. She was going to take her dog, and she said she heard a boom, and she hit the guy on the sidewalk with her mirror. My guy says he was on the sidewalk and got hit by a car. And there was an issue as to whether or not he was on the sidewalk or he was in the street. And I said it didn't make a difference because you're not supposed to hit somebody while they're on the shoulder, even if he was clearing and he should have. Anyway, that case settled for $1 million.
Those are great settlements, and I bet the clients were extremely happy with their outcome.
Yeah.
You, as a seasoned and very well known and renowned personal injury attorney here in New York, what steps do you typically take to prepare for a trial?
That's a good question. I actually lecture around the country. I just came back from a lecture from the Western Trial Lawyers Association, where I teach other attorneys at continuing legal education classes how I prepare for trial, what I do. So it's a tremendous amount of hard work. First of all, you got to make sure that all your documents are in court and all ready to go. And little things could jam up a trial. So, for example, we'll subpoena hospital records to get to, and Emily, you know, I've sent you to court to check what's in the court files. We'll subpoena documents from the hospitals and the doctors to get to court, and they need to have a certification. And who signs the certification, how it's signed. If it's not done in proper form, can stop documents from being introduced into evidence. So when somebody goes to different facilities, when the accident happened, afterwards they follow up with their doctor, they might go somewhere else for surgery, they might go somewhere else for x-rays, they might go somewhere else to get injections, they might get pain management, they might have an orthopedist, they might have a neurologist. Everybody's got to get their records in, or you can't get them into evidence, and they got to be in the proper format. And if they don't show up on time and they don't get, your case gets jammed up. So that all has to be done, and we typically make sure that's done well in advance. Then we need to get a lot of times we need to get demonstrative evidence where we'll get drawings made of the injuries, and we get artists to do that. And then those drawings have to go to the doctors to prove that they're true and accurate. And we have to exchange everything with the other side to make sure that we can get it in, because we can't surprise them at the time of trial based on court rules. Then, depending on the court, what's admissible, we might have a PowerPoint for our opening. We might have a PowerPoint for our summation. We have to get the slides out, and the judge might have to approve them. And then the judge might want us to revise them. And then on top of that, as I mentioned, we do focus groups and we're running cases, and we might change the evidence and then order presentation to make sure it's done properly. Then we got to get the right blow-ups. We have to make sure the blow-ups look good. And sometimes you have some photo and it looks good, and then you blow it up, it gets pixelated, and you have to go back and you got to get it done over, and then you crop it differently, and all the work that, because you only get to try it once, you don't get to try it 16 times until it's right. It's not like a play where every night they do a new play, or a movie or a TV show where they could go back to the editing room. It's done live, and you got to be ready. And so it's a tremendous amount of work that has to be done. And fortunately, I enjoy
it. Sounds stressful, honestly. But honestly, even today, I've had to work on a couple subpoenas, and we've gotten some back and noticed that some of the certifications weren't available. So it always takes a very experienced team and a very knowledgeable attorney to make sure that everything is correct and ready for you to go to trial, so there are no missteps. Again, we're always able to answer any of your questions. If you have a personal injury case here in the state of New York, please feel free to contact us, 1-800-321-1234. We're live every Tuesday, here to answer any of your burning questions or any concerns. If you have your own personal injury case, or if you know of anyone that has their own personal injury case, feel free to call us. Calling is free and always confidential. So Mitchell, when it comes to, all right, so let's say that a client has their case going to trial already. Is there any possibility to settle in the middle of trial? Does that ever happen?
When I was trying this last case, I was mentioned, they were the insurance carrier was calling me constantly, trying to settle the case once the trial started. Before the trial, they didn't return my phone calls. But once I started working, they were calling me constantly trying to settle. And at that point for them, it was too late. The evidence was going. They had, not only did they have their attorney in court, but the insurance carrier had a monitor in court, somebody that was just sitting in the court every day taking notes about how it was going in, how the evidence was going in, how it was cross-examining the witnesses, and they would report to the insurance carrier. And then as I was driving home at night, they would be calling on my cell saying, "Are you ready to settle this? We're going to come up with a new offer. Do you want to lower your demand?" And I said, "No." I said, "I'll have to talk it over with my client, and if he wants to lower it, we will." And he had a backbone, and he stayed in there, and we ended up doing very well.
It sounds like they got a little bit scared once they saw all of the evidence and your skill in court, honestly.
That's the way it went. That's the way it went.
So again, over 30 years of experience in personal injury, one of the, I'm not being biased, but one of the best personal injury attorneys here in New York. Always feel free to contact us, 1-800-321-1234. Mitchell, do you have any last words before we move on to a testimonial video?
Yeah, and Emmeline, you're the best, and I appreciate having you as part of my team. And I'm lucky to have all my paralegals and attorneys, but you're lovely and talented, and I appreciate everything you do. And thank you, everybody else, for listening. I hope it was informative.
Yes, and stay tuned next Tuesday for our live, every Tuesday, 6 p.m. Stay tuned. We'll come with the answers. You come with the questions.
My name is Zach Gordon. I was on my motorcycle on my way home from work on the LIE when someone in a van swerved over the double-sided line of the HOV lane and hit me, and I took a pretty gnarly tumble. I ended up fracturing a bone in my wrist. I had a concussion, as well as nerve damage in my right arm, but the worst injury was probably the ruptured disc I had in my neck, which ended up requiring spine surgery. I had the disc replaced and whatnot. In that meantime, I posted about the accident, letting some friends I had on Reddit know about what happened and whatnot, and a random person reached out to me and said, "I had an accident as well, and Proner and Proner really helped me out for much more minor injuries than you, so I think you'd have a good case with them." And next thing I know, I reached out to Proner and Proner and was almost immediately put in touch with Mitchell the same day. From that point forward, it was super simple. I signed the retainer, gave any medical professionals I saw my attorney's information, and I had to speak to my attorney maybe if even once a month once every 2 months, and next thing I know, in quite literally less than a year, the case was already over with a very, very good settlement. Essentially set me up for the future, and I'm very, very grateful to Mitchell Proner and the rest of his, I suppose, employees at Proner & Proner. And I would absolutely recommend this firm to anyone that has been in a similar situation or scenario as me, or if anyone you may know, this could not have been an easier and more desirable outcome in the process.